Hello, folks. Welcome. It's Dave Brannen here to another edition of Ask a Lawyer Live. What is it? It's June 17th. Here we are, spending another half hour, maybe an hour or so, talking about disability law, employment law, getting some updates, and hopefully answering your questions. So let's dive in today. We're going to go over, I'm still following up on my book here. This is my long-term disability guide to winning your long-term disability claim. I go through 11 mistakes that you want to avoid when doing a long-term disability claim. And mistake number 11 is what we're going to cover today. That is failing to make reasonable efforts to stay in the workforce. This is one of the biggest, I guess they're all pretty big issues. That's why they're part of the 11 mistakes, but this is an important one. It's an area that the insurance company has a lot of power to. This is a powerful argument, I guess, for judges and other people when this is brought up. So you want to be able to show that you have made reasonable efforts. That's what we're going to talk about here now. Okay, let's dive in here. So why does this obligation matter to show that you've made reasonable efforts? Well, when you are applying for long-term disability, it's not enough to prove that you can't work. You also need to show that you tried to keep working as long as possible before you went off. This comes from the legal principle of mitigation, which means you must take reasonable steps to reduce your losses. In this context, it means exploring whether you could have continued working with accommodations or help, modified duties, reduced hours, etc. from your employer. When you make those efforts and document them, you're showing that you were honest, cooperative, and committed to recovery and did everything you could to stay in the workforce. These are the kind of traits and behaviors that insurance companies, judges, and others are looking for and will increase your credibility and believability and therefore your potential success with your case. Okay, so let's look at how insurers are going to evaluate your efforts. They're going to ask you things like, what did you do to try to stay at your job? Did you ask your employer for modified duties or reduced hours in order to stay at work? Did your doctor suggest any medical accommodations or things that could be done to help you stay at work? Is there proof like emails or texts or letters showing that you tried to make these efforts? It's not enough to say that you tried. Most people in their own mind will believe that they did, but it's not enough to show that, to say it. You have to be able to show on paper that there's evidence that shows that you took efforts to try to stay at work. So if you said you were too sick to work, but your doctor suggested part-time work and you didn't even try, that's going to hurt your credibility. Okay. So the story you tell needs to match what the medical records are. So again, if you say you couldn't work, you want the medical records to also echo that by showing that you discussed it with your doctor and your doctor recommended that you take time off work. Okay, so what are some examples of what kind of things that we're looking for here that would be considered reasonable efforts? It depends on the medical condition and your job, etc. But some common examples, these are some common examples that we can see. So working part-time is something some people do to try to stay in the workforce. This one's a little controversial because you are covered under most long-term disability benefits if you can't do the duties of your work. So you're not necessarily expected to just start making less income. So if working part-time means you're earning less income, then you probably should be applying for long-term disability. But if your employer is allowing you to make some modifications without going off work completely and not losing income, then that's something you should try. But if you're going to lose income, working part-time or reducing hours, it's probably something where you should still apply for long-term disability if you're going to lose income. Now, asking if you can avoid either physically or mentally demanding tasks in the workforce, showing that you've asked for that and either were allowed to try it out or were refused, I guess. Those would be something that's something you're going to want to have documented. You want to show that you've made adjustments to your work schedule as far as possible to allow you to avoid flare-ups of your symptoms and to better enable you to stay in the workforce. Sometimes things like ergonomic equipment, like I have a sit to stand desk or a better chair or a better setup of your computer. Sometimes that is enough to show that you tried to use efforts to stay in the workforce, especially if you are suffering from things like headaches or neck pain or back pain, that kind of thing. Also, like showing that you made efforts to try for flexible working patterns, like working alternate days or adjusting your work schedule. These are all things that, depending on your symptoms, might be reasonable for you to attempt to do as a last ditch effort to stay in the workforce. Now, you don't want to put yourself to the point where you're going to have a mental or physical collapse, but you do need to show that you've explored options and gave it a real try so that your doctor said, you know what, you have tried everything you can do. Now we're going to put you off work. Okay. So, documents, I can't stress how important documents are in any disability claim. So, with your efforts to try to remain in the workforce, if it's not documented, it's going to be very hard for you to prove that you ever did anything or that there were efforts made. So the best place for you to document this is going to be in like emails or texts to your employer asking for accommodations, discussing them. That is going to be the best thing. If you have a verbal conversation with someone, you should then email them after the meeting to confirm what you discussed. You need to create a paper trail. The other thing would be, the other good documentation would be your doctor's medical records. So if you've discussed these types of things with your doctor, usually they're going to write about them in the medical record. Sometimes you might have got your doctor to write a note to your employer asking for certain accommodations. Certainly if that was done beforehand, that will be great evidence. And last but not least, not as powerful as the other two, but your own personal notes that were created at the time. So before you went on disability leave, if you create some notes of your efforts, like maybe you have like me, like a written, a written day timer type thing. You can put notes in there. Stuff like that is better than nothing. If only though, if it was made at the time that you were doing this. It's no good to go back and sort of write a history of what happened. Not as good. But notes that were made back in time around when you were trying to make these accommodations would be okay. Okay. Let's go on here. Now, what do you do if your employer won't cooperate? That's a common problem. Just because you want to make changes to your work, the employer might say, yeah, no, thanks, type of deal. That can be frustrating, obviously, but here's what you can do. Employers have a legal duty to try to accommodate someone who has a disability. So they're not allowed to just say, no, we're not going to make some changes to try to help you work with your disability. They have a legal obligation to do so. So you want to put that in writing that you've made the request to them. And you'll want to also explain why it's medically necessary for you to have this accommodation. Keep all communications with the employer, especially if they've refused anything or if there are delays with them agreeing to things. Again, if they verbally refuse, you should try to get it in writing, either by writing back to them confirming the refusal or emailing them confirming the refusal, so you have a paper trail. Then obviously save a copy of that email if it's in your work email, because you might not have access to that once you're off on a sick leave. Now, if things stall and you're having a lot of problems with the employer cooperating, that's when you can contact an employment or disability lawyer to ask about your options. Now, decision makers understand that accommodations don't always work out, but they want to see that you've tried them. And the problem wasn't that you were refusing to engage in the idea of trying to work with some accommodations. So let's look at some practical steps you can take to avoid the mistake. And again, let's go back. The mistake is failing to take reasonable efforts to stay in the workforce. So practical steps to avoid this mistake. You want to communicate early. So as soon as your condition starts affecting you at work, you want to have a conversation with your employer and have that documented. Very much along the same lines, you want to involve your doctor. You want to get recommendations from your doctor about what would need to happen in order for you to stay in the workforce. Just having your doctor just talking about it with your doctor and have it noted in their records, is that in of itself is a really big help, because it shows that this was on your mind and was an issue back in time when this was all going on. Now, obviously, you want to document everything. So keep your own notes. Like I've said, keep track of who said what and when. Yes, your own records are good, especially if they're made in real time. They're not as good when you go back and try to recreate what happened over the last couple of years. But if you keep records, if you made records 2 years ago about what was going on, those are a lot better than if you try to go back and kind of kind of write a history of what happened. That type of thing is not as effective. Now, you should act in good faith. If you think the accommodation won't help, you should still try them as long as it's medically safe for you to do so. It shows you've got integrity and that you are trying. It's like you may know in your mind that this is not going to work out, but again, nobody can know what's in your mind. It's very hard for others to judge that this is not going to be successful. You may know that it is, but that doesn't matter. People won't believe that. They'll just believe that you were, for whatever reason, you didn't want to bother. If you try it and not only try it, but show that you tried it in good faith, that you weren't there rolling your eyes and, kind of going through the motions. You don't want to do that. Use good faith effort. And if it doesn't work out, people will understand. And by people, I mean the insurance company, the lawyers involved, and the judge, the judge of your case. Now, why it strengthens your claim. Again, this may kind of go without saying, but the number one thing here is you want to go beyond just the bare details of putting forward your claim. I've mentioned that as mistake number one would just be filling out the forms and giving the bare amount of information. You're constantly trying to tell a story about yourself, and that story needs to show that you are someone who is a credible person, who's working hard, a hard worker, who's trying everything they can to get better. And showing that you made reasonable efforts to stay in the workforce is going to reinforce that type of view of you. Now, it also shows that you are credible and consistent. These are trying to stay in the workforce is something looked on so positively by all the people that will be involved in your claim, and it will go a long way to helping your credibility, which is very important for these types of insurance cases. And it is also going to show that you are not trying to game the system, that you are actually trying to stay in the workforce. This is something insurers are concerned and always watching for. They're just looking for situations where somebody just didn't bother, or on paper, it appears that they didn't bother to try that hard to stay in the workforce. Okay, we're getting to the end here. So the final advice I would give you is, even if you know you can't work now, you need to prove that you tried before you stopped. So, and that will show that you had a good reason for stopping when you did. Failing to explore accommodations or failing to document your efforts can make your claim very vulnerable, because even though the truth is that you were unable to keep working, if you can't document it, you will lose credibility and it's very hard to win it back. So don't wait, be proactive and protect your rights using the kind of advice I gave you here. All right. Now, if you found this helpful, you can always get in touch with us by downloading a copy of my book. Whoops, there it is. You can download a copy. There should be a link in the description down below. We'll send you a PDF copy of that book immediately, and you'll have the option to get a paperback version like I have right here. We'll mail that out to you along with some other goodies that we have. Okay, let's move on to our next step here. Now, if you were here, maybe some of you were here yesterday. I know I have a lot of regulars that show up. So I am going to review again this news update on the Canada Disability Benefit in case some of the people weren't here yesterday. So hopefully this will be a repeat to some of you who already saw this. So as I was saying yesterday, I got this email. There it is here. I got this email last Friday when I was away at a legal education conference. I didn't notice it till later in the afternoon, and I just said, you know what, I'll deal with this next week. So this is because I was on the email list for the new Canada Disability Benefit. But the announcement came out that as of June 20th, so in 3 days, individuals can now apply for the Canada Disability Benefit. That's good. We know that you can apply online, in paper, or by phone, I believe. No, that's not right. Let me see here. By phone. Oh, no, you can apply by phone. You can apply by phone, in person, or at a Service Canada Center. Okay. Online, by phone, in person, at a Service Canada Center. There you go. I'll just right here. Okay, right there. Boom. Now, those of you who already qualify for the disability tax credit, apparently, according to this, you're going to receive a letter with a unique access code right here. a unique access code which allows you to have a streamlined, automated process for applying, either online or through a voice interactive system. Highly recommend online. Then this voice interactive system could be a nightmare. So if you're someone who has disability tax credit, then watch for that. If you don't get it, you should still call, and I'm sure there's going to be people that get overlooked through this process. Okay, now, if you don't receive the letter and think you're eligible, you just file the standard online application. So that would be through the website or a paper application that you would print off and you could deliver in person to a Service Canada Center. I wouldn't trust the mail on this, but I guess you could mail things in as well. I would really recommend that you use the online process if you can, if you are able to, or get help to do so. Barring the online system, I probably would use the phone, even though that could be a nightmare, rather than just dropping things off. But any of these kind of systems will probably work. This just reinforces that the first month of eligibility is June, and the first payments begin in July. So if you get approved in July, then you will get a payment for July and June, and then going forward every month after that. If you don't get approved if you apply but don't get approved until like October, then you will get the retroactive payments from June to October, and then you'll start getting monthly payments after that. It's $200 a month. That's not like that is going to be a helpful amount of money for a lot of people. Like $200 is a lot of money. And so it's better than nothing, although we would have wanted to see a higher payment than that. Now, I don't know if people have questions about the benefit or anything like that. I know it's still unclear that it seems like long-term disability, non-taxable long-term disability is not going to be included, although that still seems a bit odd to me that they would not include that. But as of now, it appears that it may not be included. They're asking for you to fill out. If we go to the application page, let me go have a look at that. There is an application page where it tells you what parts of the tax code they want to see. So not the tax code. It tells you what line number they want to see from your notice of assessment, and that line usually, I think, does not include non-taxable income. So it may be that if the non-taxable long-term disability is not going to count, I'll still want to see how this sort of shakes out over the next few weeks before I give you like a definitive statement on it. All right. Let's see what else we got going on here. Now, if you want to see the website, there is really not a whole lot on it, but let's take a quick peek at it here right now. This is it here. So this is the website. And again, like there's not a lot to see here, really. The application's open. Do you qualify? Right here. So net income for line 23,600 from your 2020 notice of assessment. I'm not sure what that line is, but if you have your notice of assessment, you can go look at it. They want to see your net income. All right. So let's stop sharing that. Let me go check the forum to see if there's any questions there to answer today. There is one. There looks like there's one question. So I'm going to share my screen and we're going to go take a look at that question. Let's go take a look here. All right. Matthew's saying, hello, I've been on long-term disability for over 6 years, and I also have CPP disability approved. My physical situation is still such that I am not able to work full-time. However, I recently got an opportunity of full-time employment. The nature of the job is demanding, and I think I might not be successful in that role. However, part of me still wants to give it a try as best as I can. And my question is that before I go off on disability, what items do I need to consider? I know there is usually a clause in the insurance that the injury comes back within a certain period. I can go back on disability, but I'm not sure how difficult that process would be. Should I consult a lawyer before taking this opportunity? Also, please note this is a different company from the one I worked before going on LTD. Right. Okay. So you have to be careful. Um, First of all, when considering something like this, you would like this, you want to be upfront with both LTD and CPP disability. You want CPP disability to put you on their vocational rehab program. Now, it doesn't mean they actually give you any rehabilitation. It just means when you're on that program, you're allowed to work. They bend the rules, basically. So when you're on that program, CPP can bend the rules and allow you to earn money for a while and still get the benefit. Now, the most group insurance policies do have a now some of these recurrence policies don't apply if you go to work for a different employer. Would need to read that section of your policy or ask the insurer about it. So you could ask your insurer about it. You could say, look, I want to go back and try to work with this other employer to see if it works out. But if it doesn't, and my disability comes back and I rely on the recurrence clause, it's called recurrent disability. You could ask your insurer about that, and they might just they probably will just come out and tell you yes, they would work or no, it wouldn't. Ideally, you want to see the policy, like the group benefits booklet yourself, and make a determination. You can't always just rely on their representations, even if they think they're right and they're wrong. They will not be held to getting it wrong. Like if they give you the wrong advice and you rely on their advice, you probably are still kind of screwed. Like you have to get your own assessment of it. You can't just rely on their representations. Which sounds kind of weird, but that is how it works. Okay. Now, most of these recurrence periods are only for 6 months, but again, it varies. All right. So we'll put that in here. I think it's good news that this person wants to try. I do think it's good news that they want to try. All right, let's put that in there. Hopefully that will answer their question. I don't think there's any others. I think I got everything else up to date. Now that we're answering these, it seems like we're up to date here. Before I would go a few days or even weeks sometimes without answering these, but we're right on top of it now. Okay. Okay, we're done with that. What else do I have on my list of things here? right. Just trying to see if there's other articles that might be interesting. Yeah, no, there's not really. There's a few articles about the Canada Disability Benefit, but it doesn't really add anything to what we've already covered. Okay. Alrighty, perfect. Oh, we do have a question here. Kim is saying, what is Kim saying? For a person not attached to LTD job currently receiving CPP and PWD, when I inquired about vocational, it appears that only full-time work as a goal. What about part-time? I don't think that it only allows full-time work as a goal, to be honest. When I guess when I inquired about vocational. So you say when you inquired about the CPP's vocational, I'm going to bring it up here. There we go. So I'm going to bring up the CPP vocational rehabilitation program. Let's look at it right now. Let's look at it right now. I don't think you have to work full time for it. The insurer might have like, oh, full time is the goal. Yeah. Well, the goal of it, the whole goal of it is to get you. It's not so much part time or full time. It would be an income level that is above substantially gainful for purposes of CPP disability. So typically that's going to be full time work. So yeah, for most people, it will. Here, I'm not sharing my screen here. For most people, it's going to be full time work. But the reality is that the goal is to get you to an income level above around 20,000 a year, because that is the level where people can still potentially qualify for CPP disability. So they don't want to do this program if the goal is not for you to try to get above 20,000 a year, which is generally going to be, for most people, approaching full time work. I'm just doing a search here just to see if the word full time doesn't even appear in here. But yeah, the goal would be to get you earning more, to get you outside of the income threshold that qualifies you for CPP disability, which is around $20,000. So it would make no sense to put you in this program if your goal was just to earn like 10,000 a year. It wouldn't make any sense. The goal of this program is to get you working to a substantially gainful level, which is defined as around 20,000 a year, $20,000 a year. Which coincidentally, if you earn $20,000 a year, you would still qualify for the Canada Disability Benefit if you could also qualify for the disability tax credit. But this is an example of what this program looks like. So this is offered through CPP Disability. It's the vocational rehabilitation program. The benefits of this program is that you can return to work and still keep getting your disability benefits. They can also provide some limited level of help with planning and improving your skills. They're not typically going to pay for you to go back to school. And you continue to get this is the big thing here. You continue to get your regular CPP disability benefit. At the end of the upgrading or retraining process, your vocational rehabilitation specialist will help you look for a job. Now, if you wanted to pay for your own retraining program, they would still allow you to be paid CPP disability while you're doing the retraining. But the goal of it, again, has to be that you can get to substantially gainful work, which is for most cases going to be full-time work. Then the beauty of this program is if things don't go as the way you plan, or if things get worse with your medical condition, within the first 2 years, you just go automatically back on your claim. Then if it happens between 2 and 5 years that since you've been off on this program, then you have an expedited fast track process, but if it's after 5 years, you have to start all over again. Good question, Kim. Thank you. Now, insurance companies don't have necessarily the same type of program, but it will be described in your policy what types of things they can offer. I've been surprised recently. Like I saw a long-term disability policy recently that did have a clause in there that gave the insurer the option to pay for a bunch of things that normally they don't do, like tuition, like taking different longer courses, allowing you to continue to get your benefit while in courses. So it really depends on the wording of your policy. And I have seen a policy recently that was very favorable. It had a very favorable retraining. Okay. Anyone else have a question like Kim? If not, I'm probably going to call it a day. Kim's saying, I was trying to get off CPP disability only and only attached to persons with disability. The option to make 16. Okay. Yeah. Right. So basically, what you're saying, you were trying to get off of CPP disability and only have your money come through PWD. Yeah. I know that there's like your PWD gets reduced because of the CPP disability, and that can cause other problems and stuff like that. Okay. Yeah. Saying Kim is saying it's tricky because her health. Yeah, that is the whole problem, right? That's why CPP disability requires you to be regularly, like, it requires you to have the ability to work regularly, which means consistently. And one of the biggest problems is that medical conditions make it so you're unpredictable with your work. All right, Joey's got a question here. I'm off on WCB Alberta with a psychological injury, been off for a year. My new treatment plan is aiming for 2027. I know I can't go back. Do I have the option to refuse unsafe for mental reasons? You can, yeah. But again, like, you would need that to be certified through your doctor and have your doctor kind of make that recommendation. It's hard. It'd be hard for you to claim it yourself without the support of a doctor. Workers' comp will get their own assessments that say it's not going to be unsafe, quote unquote, for you, and you would need a medical doctor to back that up on your end. 2027 is quite a ways off, so a lot of things can happen between now and then. But that seems like a far off. That seems like a long way off for a treatment plan. So maybe it'll turn out that they never require you to go back. There we go. Let's get rid of that. All right. Anyone else have any other further questions before I take off? Do. Got different options here. Okay. All right, folks. Well, it's good hanging out with you here today. I do got to run. It's the end of my day here, so I'm going to go get some food, and then I got to do a little work tonight. I've actually got a short week again this week. I'm going to be away again for a couple days, at least from work, and I won't be on the stream here, so I won't be around on streaming here on Thursday or Friday. But I'll be back, and I might not be back next Monday as well. So probably may not be back until next Tuesday, a week from today. But I'll be here tomorrow. Take care, everyone. Have a good night.